various decisions in support of my argument, and I stand here and confirm the argument as contained in my head of argument. But let me briefly, the issue is whether the court was correct in finding that what the appellant presented was a mere reshuffling, embroidering of the already presented facts. And if this court finds that that is the position, this appeal then should or ought to be dismissed. And it is my submission that if this court finds that there are no facts in this bail application, those facts must then be reconsidered in conjunction with what had previously been presented by the appellant. But then I think it is then prudent that I therefore deal with what has been presented as new facts in the second bail application. The first aspect raised was that the appellant required medical treatment, medical care, and I had submitted in my head of argument that this is a classical embroidering and reshuffling of what had already been presented. In the first bail application, the appellant in his affidavit stated how he was involved in a motor vehicle accident and that he required further medical care and follow-ups. And he further stated that his further detention will hinder him in getting the required medical treatment. But in the second bail application, this one is repeated. He tells the court that he had complained to the prison authorities seeking further medical treatment, and that he was denied that opportunity. I submit, Buddy, that this is clearly a reshuffling of what had been presented by the appellant, and the court should not consider this as a new fact. And just to take it further on this aspect, the evidence of the correctional officer who was called by the instance of the court testified that there was no report made by the appellant seeking medical treatment. But There's nowhere in his testimony where the appellant says that the prison cannot provide him with the necessary medical treatment. He doesn't say that. And even if he raises that as an issue, on the ground that he wants to consult with his doctor of his choice, I submit that this aspect, considered with other facts presented, does not constitute a new fact. And on that point, my lady, I have made reference in my head of argument on the case of State versus Bofana. And with the leave of the court, I wish to refer to that matter, State versus Bofana, 1998 versus Volume 1, SACR 40 TK. And on paragraph 45.
This is in your heads.
This is not in my head.
Not.
But what I'm going to read is not in my head.
Not.
But I've made a reference to this matter in my head of argument. Paragraph E states as follows. Upon
Just repeat the citation again.
State versus Bofana, MPO FANA, 1998, Volume 1, SACR 40, TK in brackets. I'm going to read on paragraph E, on page 45. Upon a proper construction of Section 35, subsection 2E and F of the said Constitution, one whose detention has been pronounced lawful and in the interest of justice cannot simply resort to a further application merely because he has been detained under inhumane and degrading conditions or on the ground that his right to consult with a doctor of his own choice has been infringed. It is, however, available to such person, firstly, to apply to the prison authorities' consent and call upon them to remedy whatever complaints he or she has with regard to the conditions of his or her detention. Should the prison authorities fail to remedy such complaints, it is advisable to the detainee consent either to challenge the detention before a court of law and as being unconstitutional, or obtain a court edict to force such authorities to comply with the law. And my lady, be that it may, it is not the evidence of this appellant that he had his own doctor and that he required further medical treatment for. Anyway, this is a reshuffling of evidence, my lady. Secondly, on the new facts, there was an issue of the birth of a baby, which was submitted as a new fact by the appellant. In his first bail application, my lady, the appellant told the court that his wife was pregnant. And it is my submission that it follows ordinarily that a child would be born out of that pregnancy. And this cannot be a new fact, Mary. That is my submission. The court, when it delivered its judgment in the first application, was aware that the wife of the appellant was pregnant and the baby would follow. In any event, Marie, if this aspect of the birth of a baby is considered as a new fact, I submit that it does not constitute exceptional circumstances. In my head, I referred the Honorable Court to the case of State versus Peterson, 2008, Volume 2, SACR 335, Town Division. And it was said that inasmuch as this decision in regard to an accused bail application and subsequent appeal will of necessity impact upon a child of the accused, it may not be lost. It may not be lost sight that the child's best interests are, in terms of Section 28, Subsection 2 of the Constitution, paramount. This does not, of course, mean that such interests simply override other legitimate interests, such as the interest of justice or the public interest. Malay, I submit that this aspect, in the event that the court finds that it is a new fact, it does not constitute exceptional circumstances, Malay. And the issue of eviction of the appellant from his residence where he's renting. And also the completion of investigation in the case. And eviction and the fact that investigation has been completed. This aspect, my lady, I accept that this is a new fact raised by the appellant. But however, I state that although it constitutes a new fact, this fact taken together with other facts presented by the appellant cannot be considered as constitute exceptional circumstances. And I submit further that the interest of justice in this case would demand that the appellant be kept in custody. It was submitted before this court previously by counsel for the appellant. And this aspect is also mentioned in his heads of argument, the issue of the J50 warrant being signed by the magistrate who continued to hear the appellant's bail application. My lady, there's nothing in law that stops the magistrate from continuing to further hear evidence in a bail application where a J50 warrant has been signed by the said court. Stated that a J50 is a form of securing attendance of an accused person to be brought before court. In any event, the appellant does not raise the issue that the court was biased or lacked impartiality. If this was an issue, the appellant had a remedy. He could have applied for a review of the proceedings.
Sorry, for?
He could have applied for the review of the proceedings, or applied for refusal of the magistrate. And I submit that this fact, although it may be considered as a new fact, but this on its own does not constitute exceptional circumstances. The appellant in this case is charged with various offenses which has an element of violence, and it is my submission that the number of those charges cannot be simply be ignored by this court. The court inquired from counsel, from appellant when he was addressing the court previously. The court asked counsel as to how many charges were the accused facing at that time. Remember this aspect? My colleague only said that there were many, there were many. And I submit that it was difficult for him to say the number, because at the time that the court asked that question, the appellant was facing 20 charges. And it is my submission that there's nothing to can say that the appellant has a propensity to commit further offenses. I submit that from the past conduct of the appellant, it is clear that there's a likelihood that this appellant, if it is on bail, would commit Schedule 1 offenses. It was mentioned that at the time that the accused was arrested for these charges was on bail, was out on bail. From matters emanating from Lehlohonolo, facing an attempted murder charge and other related offenses. And my baby, after his release on bail, all these offenses were then committed, were allegedly committed. Clearly, this is a person who does not want to find himself living in the civilized citizens of the country. And his conduct clearly undermines or jeopardizes the public opinion, rather public confidence in the criminal justice system. He was on bail when he was arrested for these charges, as I said, and clearly, my lady, normally that is a violation of the bail conditions, because normally the court, when releases you, will say you should not commit children offenses, and he committed them. And I submit that the appellant has got no respect for the law, and if he is on bail, it will be wrong to release this type of appellant on bail. I therefore submit that the appellant has failed to discharge the onus on him in proving that exceptional circumstances exist that would justify his release on bail. In the event that the court finds that there are no facts raised, and I submit my lady that this appeal should be dismissed. But those are my submissions.
Thank you, my lady. My lady, as previously alluded to, I'm at a bit of a disadvantage because I wasn't involved in the proceedings before, but I undertake insofar as I can possibly do so to avoid any form of repetition, and I need to deal with that which has been addressed to your ladyship today. However, my lady, in order to do so, and with respect to your ladyship, I just need to trace a very brief, and it won't be more than 3 minutes, outline of the matter. And I'm not rehashing or re-arguing the matter, it's just to introduce my response to my learned friend. So, my lady, in this matter, the appellant was arrested on the 12th of November 2025. And your ladyship is aware that at that stage he'd been requested to come to the police station. They'd been to his house to look for him. He went to his attorney's office, and he was found at his attorney's office. And he said, and it's never been disputed, that he was about to hand himself over in the presence of his attorney. There'd been a previous incident where he had done so as well, so it's consistent with his conduct. At that stage, my lady, it was well known that it was a Schedule 6 bail application, and that the appellant had one previous conviction for shoplifting, and a pending case of attempted murder, with 2 charges of assault with intent to do grievous bodily harm, on which had been released on bail of 5,000 rand. Here comes my first issue with my learned friend, your ladyship.
I'm going to ask you to please go a little
I
slowly
apologize.
so I can record
I have
it.
notes I can repeat. At that stage, my lady, he had a pending case of attempted murder with 2 counts of assault with intent to do grievous bodily harm, in which he had been released on bail of 5,000 rand, and he had complied and attended court at every instance. Here is my first issue with my learned friend's address to your ladyship. He contended to your ladyship just now, a few minutes ago, that the appellant had breached his bail conditions by committing a Schedule 1 offences, and that was part of his bail conditions. Now, my lady, that's not the case. The bail conditions are clearly set out on the record. At no stage did any court tell him, and I know it's a given that one shouldn't commit offences, but to exaggerate that to a breach of bail conditions is incorrect with respect to my lady. So he hasn't ever breached his bail conditions. This becomes very, very significant, my lady, simply because this appellant had been released on bail on all of these charges previously. At least one of which, Your Worship, was a schedule, my lady, I beg your pardon, at least one of which was a Schedule 6 offence, where it had been found by court, and this is part of the heads of argument, that there were exceptional circumstances that justified his release on bail. So, my lady, at that stage, and this also answers my inference addressed to your ladyship and your ladyship's question to my predecessor in this matter, the appellant was facing 9 charges, because your ladyship had asked the question, how many charges did he face? My inference says 20. You won't find that with respect anywhere in this record, my lady. So it's an over-exaggeration yet again. The charges, my lady, can be summarized, and as I said, I won't go into too much detail. Counts 1 to 3 are 1 incident of attempted murder, malicious injury to property, and possession of a firearm. Count 4 is related.
For record purposes, is this a licensed firearm or an unlicensed firearm?
It says unlicensed, my lady.
Unlicensed
Yes, my
firearm.
lady.
So that offence would have brought the, outside of the attempted murder, and depending on the date, brought into effect the Criminal Law Amendment Act as far as punishment is concerned.
Yes, my lady. My lady, yes. But I understand that all of these charges were previously withdrawn, but they've been reinstated, which is another issue which still has to be resolved. And you'll see, my lady, it becomes significant because of the nature of the other charges that the appellant currently faces that have been reinstated against him. Count 4, my lady, also pertains to a firearm, where gunshots were fired where Mr. Malachi had claimed ownership of the firearm and contended that he had fired the firearm. Count 5, again, relates to possession of a firearm which has been withdrawn. Count 6 relates to the Masilele encounter, my lady, where there's a dispute as to whether it took place in 2025 or 2014 to 2015. There's uncertainty in the record as to that. Count 7 claims to have been mediated and it had been signed off by a magistrate. Count 8, my lady, related to an allegation of being stabbed with a bottle. And the final count, my lady, count 9, pertains also to a firearm where the appellant gave a version that it was they were shooting a video, and that it was a makeshift or a toy firearm that had been utilized. Now, the important aspect of these 9 charges, my lady, is that the appellant dealt with each and every one of them in his affidavit, gave a totally exculpatory version, which has never been disputed. My lady, those allegations were dealt with in the first bail application, but in an appeal relating to new facts, one has to have regard to the full record. One cannot ignore those facts. What then happened, my lady, is that matter resulted in the appellant not being granted bail. It went to the High Court, and we have the judgment of the Honourable Mr. Justice Burnett, who delivered that decision, which then was the forerunner, my lady, to the second application based on new facts. That affidavit was filed before the Regional Court, the Court on the 21st of April 2026. And there's one very, I beg your pardon, my lady. 21st of April 2026. And I'm indebted to your ladyship for stopping because it gives me a chance to clarify also the argument, my lady. My lady, in that affidavit, the appellant set out the new facts upon which he relied to approach the magistrate, the court of quo yet again, with the view to reconsidering the issue of bail premised on new facts. And this is where I have a fundamental issue with my learned friend's argument, my lady. He seems to conflate, and I'll explain to your ladyship in what manner he did so, but he seems to conflate the two onuses, the one being to establish new facts, and the other being to satisfy Schedule 6, wherein the onus is that the appellant must show that there are exceptional circumstances which justifies release on bail. I do accept, my lady, that the new facts have to satisfy that element at the end of the day and that onus. But in this regard, my lady, the most significant issue that both the magistrate and my learned friend keep on ignoring, and it stands out, as they say, so it's a pole of water, it stands out, it's poking them, it's the rod that's poking the bear all the time, my lady, is that the argument that was presented as the very first issue before the regional magistrate was the issue relating to the congested role in that court. And it was common cause, as I understand it, my lady, that there is only one regional court that deals with criminal matters in that region. That's in this honourable court's jurisdiction.
I think that must be a correction. Unfortunately, Polokwane is just the one court here in Polokwane. But we have Sesheko, we have Mankweng, we have...
there are others as well. I agree with you, lady.
There are various regional courts in the area itself.
Yes.
Polokwane is just basically centralized for Polokwane area. Sesheko got its own, Mankweng has its own, and Lehlohonolo has its own. So all the suburbs surrounding Polokwane town have their own as well. So I appreciate Polokwane may be on the allegation. I'm not saying that it is a fact. Based on the allegation that Polokwane may have a congested road, I cannot say that it's the only regional court for the region. That would be an incorrect summation. I'm indebted
to your ladyship, but my lady, that was the version that was put on the affidavit and has never been dealt with by either the state, being the respondent in this matter, or the magistrate. So the allegation was made, and I take cognizance with respect. I'm indebted to your ladyship for pointing out that there are other courts, but no attempt has been made to transfer this matter to another court where one could have an expedited trial. That would be welcomed, my lady, because that would resolve possibly the first issue. But on the record, my lady, the argument was placed before the magistrate, and your ladyship is aware of this because it stands out in the record, as I said, that there's only one regional court, there's a congested role which will result in long delays, and it will take years for this matter to be heard. And they said that they're setting trials down that predated this trial in September of this year, and in all probability this matter would only be heard in next year or in the following years to go. Added to which, my lady, there's the problem of the discontinuous role in the regional court, unlike the High Court, where matters get remanded for a number of days at a time, and then they become part heard, and then they're set down for another series of dates. So that was the first issue, my lady, that my learned friend and the magistrate had not dealt with under the title of new facts. The second issue, my lady, that appeared from the affidavit, which my learned friend did touch on, but not in the detail required with respect, was that at the stage when the affidavit was filed, which was April 2026, it was common cause that he had been in custody for 5 months already, and that he had not received psychological attention, and he was suffering both medical and financial prejudice. They were lumped together in the affidavit, my lady, those three issues. It's the period of custody, of being in remand custody at that stage, with those three issues. Now, in that regard, my lady, the issue that my learned friend fails to appreciate is the complaint, as I read the record, is that the appellant did, on numerous occasions, request medical attention. He had placed on record that he had received a very serious injury and lost a child in the motor vehicle collision, and he had requested medical attention, and he was in need of an urgent operation. And the screw had come loose that was holding the bones together. What then happened, my lady, and this is the nature of the complaint that I submit my learned friend doesn't appreciate, is the complaint was that despite his numerous requests for medical attention, this had not been attended to. My learned friend argues that he knew about the collision in the first bail application, knew about his injuries, so it can't be a new fact. That wasn't, with respect, the essence of the new fact. The new fact was the failure by the Department of Correctional Services to assist him by securing the medical and psychological attention that he was in so desperate need of. That's the complaint, and that's what, with respect, prompted the magistrate to call the evidence of that Miss Nkosi, who then came to testify as to what the procedure is. And my argument in that regard, my lady, will be that she didn't take the matter any further, but most significantly, insofar as the magistrate sought to call her with a view to explaining the procedure of how one seeks and obtains medical attention, she didn't deal with the issue that had been placed before the court by the appellant, in that he complained that he had not received medical attention. He said, despite his numerous attempts, and she couldn't dispute that he had made the request and that the authorities at the Department of Correctional Services had the duty, and it's a statutory duty, to see to it that he received the medical attention. That's where, with respect, the magistrate to a certain extent played his hand further, in that he called the witness, the state didn't, and the witness wasn't called just to explain the system, it was to, if I may put it as strong as this, may rebut the appellant's version in that regard. But she didn't succeed with respect in doing so. The next new fact, my lady, was the centralization of the old matters. And this was put forward as the third ground in the affidavit, something that my learned friend and the magistrate haven't dealt with. I understand your ladyship expressed the view, and I'm in respectful agreement, my lady, that it's the state has the discretion to do so. It's incumbent upon them in terms of the Criminal Procedure Act to centralize matters, but it becomes somewhat troublesome, my lady, with respect when they do so in respect of matters in which the appellant, in this case, had been released on bail previously. And it's a matter of practice, my lady. There's no law that dictates it, and this will be my argument, that in such instances where a person has appeared before court religiously, complied with all the bail conditions, and let me put it out there, my lady, even if there's suspicion as to how the charges were withdrawn, but in this instance we've seen the annexures, my lady, they're all there, where it shows that the prosecutor in open court requested withdrawal of the charges. The usual practice, my lady, it's not a rule of law, but the usual practice is that the J175 is issued and the person appears before the court, not an arrest and a rehashing of a Schedule 5 or Schedule 6 bail application, where it was common cause, firstly from his prior conduct, and secondly from the manner in which the matters were withdrawn, that he had complied with all his bail conditions. Your ladyship will see this in the documents, my lady. It's the annexures, LKC 1, 2, and 3 deal with the different CAS references, where your ladyship will see that it's in each instance that the prosecutor came before the court and requested, in the one instance the complainant hadn't bothered to come to court, but had expressed a view to the prosecutor that they want the charge withdrawn, and in the other instances the prosecutors had secured affidavits of withdrawal. So the argument that was placed before this Honourable Court in that regard was that this is a backdoor approach to the bail applications, but it's common cause, and it cannot be disputed by my learned friend that in all of those instances the appellant had complied with his bail conditions. So much so, my lady, that I understand from the record here that there was an attempt at one stage to reconsider or to challenge the bail that had been set in the matter that's still pending, in which bail of 5,000 rand had been set, but that was abandoned as it appears from the record. The next issue, my lady, which is quite a contentious issue, and something that I don't honestly know the full answer to, is the fourth ground was that the magistrate granted the warrant. In terms of Section 43 of the Criminal Procedure Act, my junior, my opponent, my learned friend, and myself cannot find a case anywhere that says that he may not then hear the bail application. And once again, it becomes a question of practice. But what ought he to have done in those circumstances? My submission would be, my lady, that he had a duty to disclose. I put it no stronger than that. And that's the failure, the first failure by the magistrate. I sincerely believe that if, as is the case here, he had reviewed an affidavit by an investigating officer in terms of Section 43 that made out the case for the arrest of the appellant, when he saw the appellant before him, he ought to have said, I issued the warrant in this regard. If there's a problem, please let me know. And this becomes even clearer, my lady, by virtue of what your ladyship told me today, which I hadn't taken into account, and that's that there are other regional courts. And there are other courts that could have heard this matter.
I think it would be correct, and I will be set straight by both the state and your instructing attorney. I do not believe this matter was heard by the regional court.
No, it's the district court. As I said at my day, I realize what I'm saying. But the same argument should, I beg your pardon, my lady.
That dealt with the bail application.
Yes.
And from what I understand, this is the chief magistrate of that district court.
As your ladyship pleases. But
I will be corrected as far as the name is. I can't just get it right now. But for all intents and purposes, it's the chief magistrate of the district court who was responsible for signing the J50 and then dealt with the first appearance bail application.
And the second.
My question would be then to counsel. If we feel so strongly about this, and it came through on the bail appeal where the court on appeal indicated this is a new fact, this was never ventilated, I cannot entertain it now on appeal. Why was that not an aspect that was ventilated on the bail on new facts before that presiding officer, concerning that presiding officer's role and the need for him to recuse himself in total, which would then have set the wheels of justice straight? We could have reverted back to square one, having it be placed before another presiding officer because of the refusal to grant, the refusal of the recusal application would be a ground one would take up then for review if one is so inclined. Alternatively, the court would then be made alive to the fact that we seek your recusal simply on the basis that you may have been prejudiced by your conduct by issuing the J50. We believe that it would be in the interest of justice on the new facts to proceed by way of your recusal, and this matter be heard de novo, because it is a new facts application, but it would then be in total heard by a new presiding officer. Why was that not ventilated? I just feel that on appeal, one is bound by the record of proceedings, but where these aspects were never ventilated by the orchestrator, who would be yourself in the shoes of your client, why this now becomes such a contentious issue for an appeal court to now find the district court was incorrect. They should have recused themselves if it was never sought.
My lady, just as that was a very long question, I apologize in advance. My answer is going to be equally long, and let me explain myself.
But I gather
yes,
you,
I understand.
You understood exactly
I understand
what
fully,
I was trying
my lady.
to bring
It's
home.
a very complicated issue, and I understand, but I need to explain it in great detail, and I have no difficulty in doing so. So the first issue, my lady, is that it's obvious that the appellant and his legal representatives at the first bail application were unaware of that fact. It only came out later. In fact, it came out in the first appeal, and then it arose as a new fact. So that's the first time it became known. So it qualifies with respect, if I can use the term, as a new fact. It was then put before the magistrate, my lady, but as I've said, and I'm repeating myself, there's no authority dealing with this, and I've searched high and low for it, as did my juniors, far better at researching with the new technology than I am, and I make that concession. But the point is that there's no case that deals directly with it. This was then placed before the magistrates, and you can see with respect, my lady, in his judgment, which was then, it was then too late, but in his judgment, he took umbrage, he took it very personally. And he dealt with it on two occasions, insofar as, firstly, he said it was arrogant to have raised this issue. Now that in itself shows that there was a perception of a personal attack. So he of his own accord ought to have recused himself for the very first ground. Secondly, my lady, it becomes even more significant when you look further down his judgment. In his parting concluding remarks, he says he was thrown under the bus by the defense attorney by raising this issue. So that reinforced the personal manner in which he saw this attack on him having issued the J50. So it was incumbent upon him, and using my learned friend's quote, it would have been in the interest of justice if he took it so personally to there and then recuse himself mero motu, and he ought to have done so. And thirdly, and more significantly, my lady, because this then was the conclusion, it was then too late to say, oh, you've expressed in a personal opinion, recuse yourself, because it's the parting remarks of and the concluding remarks of his judgment. But when one takes a holistic view now and looks at those proceedings and says, well, let's just look at what happened in this application on new facts. Firstly, the state took what could only be described as a supine attitude. They did not put forward any form of defense to the allegations of the new facts. They did not dispute them, and they did not sincerely oppose in any manner the bail application. It was the magistrate who called Msinkosi. And that's why I say Msinkosi was called to dispute or refute the appellant's version, which then shows he's now played his hand. But he still hadn't expressed the view that he took it personally, that he had issued the J50 and that this was an issue. That only came out in the judgment. And that would explain, with respect, my lady, those three steps that I've referred to, why this was never taken before and why this court is now faced with it. Because I come in only at this stage, my lady, but I still understand. No, and I'm not going to make excuses and divorce myself from that conduct, because I align myself with it. And I understand that the appellant appeared, it was an application on new fact. The new fact had only arisen on appeal raised by the judge, and I think a very valid point. And thereafter, it was brought to the magistrate. He didn't take umbrage at the time. So it's not as if he said, how dare you say this in an affidavit? How can you throw me under the bus? Don't you find this too arrogant? He waited patiently, my lady, until after he had called his own witness who, with respect, didn't take the matter further to then take issue in that regard. So if one takes now, and it's easy ex post facto and with hindsight, they say it's 20/20 vision, my lady, to say, well, now let's look back and see, is there really something to it? And I'd say yes. In these circumstances, there is. Particularly as your ladyship told me that there are other district courts, and I correct myself from earlier, there are other district courts that the magistrate could have referred the matter to. So first thing that I believe he ought to have done, my lady, with the benefit of hindsight, is say, I issued the J50 in this matter. Do you take any issue with me hearing the matter? If they said yes, then he ought to have referred it to another court. When we look back at the personal attack that he perceived in this regard, it becomes even clearer. So I submit with respect, my lady, that that's something that the state, the respondent, my learned friend, have not dealt with and ought to have dealt with, but it does, with respect, clearly present itself as a new fact. What the result is, my lady, as to whether he ought to have disclosed or whether he ought to have recused himself, with hindsight we can say he should have, but is that a new fact? I say yes, it is, with respect, and it was taken personally. The fifth new fact, my lady, raised by the applicant in this matter, which my learned friend did touch on but not fully, was that he had been involved in the serious motor vehicle collision. He had lost a child, and that he was seeing a psychologist, and in this regard he had called his doctor Moka to come and testify as to the need for his surgery, which was dealt with in LKC 4 and 5 of his affidavit. And he further went ahead and said that he's suffering from serious pain and that the screws had come loose and he needed medical attention, which led to this issue with Ms. Nkosi testifying, and that would account for the annexes LKC 6 to 9 with the photographs of the screws loose. So it's something that cannot even be disputed with respect. And if we stop now and say this is bail, let's take cognizance of where we stand. To date he hasn't had the operation, but even at the time of the hearing he hadn't, and it was clear that the authorities had never reported it. So it's a new fact, not the fact that there was a collision and there was an injury, the failure by the correctional services to honour their statutory obligation, ensure that he received medical attention, and that is a new fact that cannot be disputed because he hasn't had the operation. The sixth issue, my lady, and I do take issue with my own friend, is the birth of the child on the 1st of December 2025, when the appellant was in custody. To say that someone's pregnant is almost like saying that's my child, but you don't know until the child's born and you do the tests. So there are lots of unknowns with respect, and it changes the status. And when a woman is expecting, she can still work, she can earn her living, she can do things, but once she has a child, there's another mouth to feed. It is with respect a new fact. There's an emotional bond, there's a need to see one's child. This appellant has not seen his child since the child was born on the 1st of December when he was in custody. There were other issues, my lady, that were raised as new facts. There was a letter of demand, there was the threatened eviction. Those were facts that had arisen after the bail application had been refused. And then the second last one was that he had received awards and support whilst in prison, which they said is unheard of, that a person receives awards still whilst in prison. And then most significantly, my lady, or more significantly, is that there were a whole lot of petitions that supported his release. Because my learned friend argues that society will be upset and the interest of justice will be tramped upon if he's released on bail. But there's nothing to support those submissions. There's only evidence to the contrary in the form of all the petitions that were signed calling for his release. So if we ask what's the public outcry, it's quite clear that the public outcry is for his release. There's nothing to counter that was before the court. In that regard, we've referred to the case in our heads of argument of JB versus S. It's an unreported decision where they say the prominence of a person or what he stands to lose by virtue of his fame and reputation is a significant factor that can be regarded as an exceptional circumstance. Now, over and above these new facts, my lady, what was never dealt with in any of the judgments previously, and I am repeating myself, my lady, is that having been released on bail in all of these matters, the appellant had always complied with his bail conditions. And this even goes to the fact, my lady, that some of the previous charges that have been reinstated were Schedule 5 and Schedule 6. So what the state has said is that accepted previously that the interest of justice were served by his release on bail insofar as there were Schedule 5 offences that he'd been released on bail on and complied. But even insofar as there were Schedule 6 offences previously, the state had agreed that there were exceptional circumstances that justified his release on bail in those instances. Now in this matter, as your ladyship knows, but my little friend didn't deal with it, the general practitioner, the Dr. Chauke, came and testified in support of the need for the operation, which has never been dealt with. So the injury was there, but the failure of the system of correctional services to attend to it is the new fact, my lady, not that the injury was there. And that was the subject of all the cross-examination, but nothing was accomplished through that. Now, dealing with today's argument, that was the first issue that my learned friend raised, my lady. He said that this was a mere reshuffle, but it isn't, my lady. The medical treatment wasn't there at the time of the first bail application. It's a new significant factor. I would submit with respect, even in exceptional circumstance that satisfies both onuses. One mustn't conflate them as I'm going to argue that he did, that he ought to have been operated upon already, and that the evidence of Mr. Nkosi made it even clearer how the system had failed him in this regard. To then argue, as my learned friend did, that there's no report by the appellant that he sought medical evidence is false with respect. He made it clear that he had asked every person who had come to see him that he wants to have this operation. He's in terrible pain. He had the x-rays and everything to confirm it. So it is a new factor that ought to be taken into account as a new fact, and it is as well an exceptional circumstance that would justify release on bail for a Schedule 6 offence, because to keep somebody there with the bones growing the wrong way, with screws that have come loose, is a factor that should be laid at the door of correctional services. I've dealt with the second issue that he raised, my lady, and that was the birth of the baby. I'll repeat that it is a new fact in our respectful submission, And this is where my learned friend conflated the two standards of exceptional circumstances and new facts. He said, this is not exceptional to have a baby. I agree, it's not exceptional to have a baby. It is a factor, and it could, with respect, qualify as an exceptional factor, because it was anticipated, but there's still the emotional bond and the need to pay for that child once it's born that arises from the birth. Had the child, God forbid, been stillborn, it would have been a different situation. There'd still be an emotional issue, but there wouldn't be the financial issue. But these are the unknowns. So with respect, my lady, I submit that even the birth of the baby qualifies both as a new fact and an exceptional circumstance that ought to weigh in favour of bail being granted in this matter. My learned friend then dealt with the eviction and the rented premises, and that the investigation had been completed together, but I say they're separate. He conflated those two matters together, but he accepts that the investigation is complete is a new fact. So that in itself, my lady, ought to satisfy the requirements both of only of a new fact. My lady, it's normal in all investigations that eventually investigations are completed, but it would be a new fact because now we're in a position where, even though there's no evidence to confirm that the appellant had ever interfered with any witnesses or any investigations in any of the matters that are before this honourable court, there's no possibility of any interference because it's now a fact that it's been completed and they have all the evidence that they wish to use against him. And it's important, my lady, that in this regard, there was a Schedule 6 application before and bail had been granted. He then dealt with the magistrate signing the J50, which I have dealt with, my lady. I'm not going to repeat myself. And this is where he said that there were 20 charges, which I say doesn't appear from the record anywhere, my lady. I've been requested to point out to your ladyship, and it is a significant factor, that in support of the appellant's contention that he didn't receive medical attention despite the fact that he reported it, and my learned friend submitting to your ladyship that he never reported his medical condition, letters were written by my instructing attorney, Mr. Michael Kumalo, recording that he requires this medical attention, and there was no response ever received. That's on the papers, my lady. It's in the record. It's in the affidavit that was filed. It was handed to the court as well. The letters are there. They're in this record. So that's a matter of fact, my lady. So it cannot be said that the failure to provide medical attention is not a new fact. It's an absolutely new fact, and it's a very significant one that on its own ought to result with respect in this appeal succeeding. So, my lady, my final submission, unless your ladyship wishes to hear me in any particular aspect, is the issue pertaining to the centralization of all the charges which resulted in these 9 charges that the appellant now faces is a knife that cuts both ways. On the one hand, my lady, it might tend to show a propensity to commit offences, but on the other hand, it shows that in every instance in which the appellant was arrested and had to face bail conditions, he complied. So one looks to the pedigree of the dog or to the history of the matter to say, what do we learn from history? We learn what ought to happen in the future, because that's the lesson of history. Historically, this appellant has always complied with his bail conditions. He's always respected the court. There isn't one instance where the state can say, he never appeared, or he gave us a runaround, or he didn't present himself. He presented himself, they said, even intoxicated in the one instance. He was on his way with his attorney, and it's undisputed in respect of this current matter with all these charges. So that in itself, my lady, is an exceptional circumstance that would justify the granting of bail on a Schedule 6 offence. That isn't a new fact, my lady. It was something that was always there, and it was recorded in all of the bail applications thus far. So we have two standards here. Firstly, to succeed on appeal in this matter, we need to satisfy this Honourable Court that there are new facts that justify a reconsideration premised on those new facts. They're set out. I've repeated them to your ladyship. I do respectfully submit that we've satisfied that element. The second stage, my lady, would then be to say, well, would that satisfy the requirements of a Schedule 6 bail application, in that do those new facts constitute exceptional circumstances? My learned friend conflates the two. I ask your ladyship to do two separate considerations, and to firstly find that there are new facts. Secondly, those new facts do satisfy the onus of a Schedule 6 bail application, in that they constitute exceptional circumstances which justify the release of the appellant being in the interest of justice. I thank you, my lady. Unless your ladyship has any further issues for me.
I'd like for you to please assist me. Hopefully you've been brought up to date, but since the last appearance in court, I believe that the issue pertaining to the transfer to the regional court occurred between the bail application on new facts and the appeal proceedings, where the matter was then referred to the Polokwane Regional Court for purposes of hearing.
Yes.
Since then, what is the circumstances in respect of your client? Has his medical attention been received? Has his psychological attention been received? And where is the case as far as the trial itself is concerned? Has the pre-trial conference been held? Has the matter been set down for purposes of hearing for trial? Because, and I take this as judicial note, the proceedings get transferred to the regional court on a normal course after investigation is finalized, so that the regional court carries the trial of the matter. So if you have indicated investigations as finalized, I can accept now that we are in the next phase of this proceedings, where pre-trial conference would be arranged, trial dates would be arranged, etc. I don't know what happened when we last dealt with the matter till we're dealing with the matter now, whether or not the accused, the appellant in our case, appeared in the regional court, and whether or not anything has been doing and happening. I do believe the state is the prosecutor in the regional court proceedings, and I suspect Mr. Kamalo is the defense in those proceedings. So maybe direction can be afforded this court concerning those aspects. Because obviously, this court is obliged to take cognizance of it is a new fact, but whether this new fact has, in the interim, had something happen or not.
My lady, I'm more indebted to your ladyship for this inquiry than your ladyship fully appreciates, and let me explain myself. When I began, my lady, I said that there was a very recent judgment from the Western Cape which I had omitted to hand to your ladyship and my learned friend. There's a decision of Nicole Tracy Johnson in the state, of Pangaka J in the Western Cape division, that was delivered after all the heads of argument in this matter, my lady, but would have an impact on this matter in my respect for submission. It's dated the 24th of July 2026. It's a lengthy judgment which I'll hand to your ladyship and my learned friend, which might provide some guidance, and it turned on the issues that your ladyship has asked me now. If I may hand a copy to my learned friend and to your ladyship. Thank you. Essentially, my lady, and it's 37 pages. I'm going to go into the detail. I understand your ladyship will need time to read this, as would my learned friend. But in that matter, the court took into account as a new fact. It didn't accept any of the other new facts, but the factor that influenced the court in granting bail was exactly what your ladyship had asked me now. And that was that this lady had been in custody for 30 months, almost 3 years, and that there was a degradation of her psychological well-being which hadn't been treated, and her daughters as well. Her daughter was 18, so she'd reached the age of majority, but they took into account that she was still a dependent child, not within the legal definition of child, but still at school. So it was a fact that they took into account. So in relation to, there were 3 questions that your ladyship asked me. 2 I can answer. The medical and psychological treatment, the answer is 0. Nothing has happened, my lady. And that's why this judgment becomes important, the Nicole Johnson judgment, and I know my learned friend didn't have a chance to read it, but it will just assist, my lady, to see all the grounds we dealt with there. It's a very, very composite and well-structured judgment that deals with all new facts in the law and all the cases that my learned friend and I have referred to, and finds that the only significant new fact there was the psychological well-being or degradation of the remand detainee and her daughter, which resulted in bail being set in that matter. So I can answer your ladyship and ask your ladyship to kindly take judicial cognizance of the fact that as we stand here today on the 30th of July 2026, both his medical and psychological issues have not been attended to. Insofar as the transfer to the regional court, I read somewhere in the record that a date had been set. I'll just ask my instructing attorney, and that thereafter it's going to continue to trial, but it hasn't. The trial has not yet commenced. I know that they were present, and I apologize. May I take an instruction, my lady? I understand the matter has been postponed to September, my lady, but not for trial. That's to transfer it to the regional court with a view to receiving representations. That's I read it in the record as well, my lady. I'm just not certain of the date. My learned friend would know the date because, as you said...
I'm going to just ask for clarity from the state side.
Yes.
Just for the purpose of, I would think that it might be postponed for purposes of representation to September. But I definitely believe it is right now in the regional court. So it can't be transferred to this regional court again.
Yes, no, it's I understand it's 10 September, my lady. Yes. Thank you, my lady.
My lady, I'm not the prosecutor.
You're not doing the case.
But my colleague here, the prosecutor, my lady, I'm informed that the matter has been postponed for the appellant to make representation to the DPP's office. The matter is in the regional court and is right for trial.
My lady, I've received instructions that it's postponed to 10 September. It had already appeared before the regional court. It's for representations. At that stage, they asked the regional magistrate to endorse the warrant of detention so that he could receive the medical attention and the psychiatric attention, and the magistrate refused to do so. That's a matter of record, I'm told, by my instructing attorney. And my junior conveyed it across, but my instructing attorney, who's present in court, was there when that occurred. Thank you, my lady. I have no further address, my lady. If there's anything further to ladyship wishes to inquire.
I do believe that at the previous instance when the appellants placed aspects before the court, the indication was that if bail was to be considered, the appellant was financially in a position to pay bail. They suggested an amount of 10,000 Rand that was on the papers. I just want to confirm that was what was ventilated.
My lady, I have instructions in that regard. The appellant is in a position to pay bail of 100,000 Rand.
100,000.
Yeah, it's not. He's got family and friends that have undertaken to support him to the extent of 100,000 Rand, and he would comply with any bail conditions as envisaged in the Branco decision, my lady, including but not limited to house arrest, etc., where he could be monitored by the investigating officer. He will cooperate in any possible way, my lady. Thank you, my lady.
I take it there's no comment on the state's part in this regard.
My lady, I indeed informed that what was proposed initially was an amount of 100,000 Rand.
100,000 was initially proposed.
Not 10,000 Rand.
Not 10,000.
Yes, but
okay, I didn't. I'm sure I did 10, but be that as it may, it's fine.
Yes.
It was originally 100,000.
Yes, but the state is opposed.
No, but I hear you.
Yes.
I don't think that was going to change. Otherwise, we wouldn't be here. Right. I was contemplating trying to give an extempore judgment in respect of this matter. I was just wanting to ventilate the issue with the parties. availability concerning judgment being delivered concerning the matter?
We will comply with whatever your ladyship orders. We have no issue, my lady.
Whatever suits the court, my lady.
Would you be available then next week?
My lady, my attorney will fit in with any date if I can be excused.
Obviously.
And my junior, but my attorney will definitely secure any representation that accords with your ladyship's arrangements. There's no issue, my lady.
Right. The matter is going to be postponed for purposes of judgment on the 5th of August 2026. It will be here in this court, courtroom number 5 at 9 o'clock in the morning.
Yes, the court please.
That concludes our bail, my lady.
The court shall then adjourn. Please be quiet. The court is still here.
Thank you, sir. Thank you. Good morning. Good morning. How are you?